Hello and welcome back to the deep dive. It is great to have you with us. Today, we're going to do something a little bit different. We are going to talk about something that, well, everyone has. You have them. I have them. Secrets.
Secrets are just a fundamental part of being human, aren't they? We all have these little boxes in our minds where we keep things just for ourselves.
Exactly. But here's the problem. Imagine you're in a courtroom. The big chair, the judge, you raise your right hand. You promise to tell the truth, the whole truth, and nothing but the truth. That room is designed, really, to break open those boxes. So, what happens when your secret meets the law? Who wins?
That is the big question. And usually, the law wins. The default position is you have to speak. But there are these special exceptions, these incredibly important rules called privileges.
Privileges. Now, when I hear that word, I immediately think of, a privileged person, someone with a lot of money or status, but that is not what we are talking about today, is it?
No, not at all. In the legal world, a privilege is much more like a shield.
A shield. I like that.
Yeah, imagine you're a knight, and the lawyer on the other side is trying to hit you with questions, which are like arrows. What did you say? What did you do? If you have a privilege, you can just lift up your shield and say, stop, I do not have to answer that. The arrow just bounces off.
Okay, a shield. That's a great image. So today, we're going to be looking at our source material, a guide called Legal Privileges and Confidential Communications. And our mission is really simple. We want to figure out, who can you trust? Can you tell your husband or wife your deepest, darkest secret?
What about your doctor? Or the one we always see on TV, your lawyer?
Right. When are your secrets safe and when are they not? And we're going to do this in the simplest terms possible. No fancy lawyer speak, just the basic rules of trust.
Sounds like a plan.
So let's start at the very, very beginning. Before the courtroom, before any lawyers, we just have a secret. What is the absolute #1 golden rule for keeping that secret legally safe?
The #1 rule is a long word, but a simple idea. Confidentiality.
Confidentiality.
Look, all it means is privacy. If you want the law to protect your secret later on, you have to act like it's a secret now. You have to protect it yourself first.
Okay, let's paint a picture, a scenario. That always helps me. Imagine you and I are in a room. It's just us. I lean in really close and I whisper, I stole a cookie from the cookie jar.
Okay. In that moment, that's a confidential communication. You created a little private bubble just for the two of us. You intended for only me to hear it.
We're in the bubble. Got it. Now, let's say a stranger walks into the room. Let's call him Dave. Dave just happens to walk in right as I'm whispering. He hears me say, I spill a cookie. What happens to my bubble?
Pop.
Pop. Just like that.
Just like that, it's gone. In the eyes of the law, Dave is what we call a third party. He's a stranger to our special relationship. And if the third party hears the secret, the law basically shrugs and says, well, you must not have cared about that secret very much because you let Dave hear it.
So because Dave heard it, I can't use my shield later in court.
Exactly. If the judge asks Dave, what did you hear? Dave has to answer. And if the judge asks you, did you say it in front of Dave? You have to admit that you did. The privilege is broken. It's waived.
That seems really strict. I mean, what if I didn't even know Dave was there?
Now that's where it gets interesting. That's the exception. Let's change the story. We're in a room. We close the door. We lock it. We check under the table, look behind the curtains. We think we are completely 100% alone.
Okay, we've secured the room.
But we don't know that there's a spy hiding in the closet. A professional eavesdropper with a little listening device.
A spy in the closet. Okay, so I whisper my secret. The spy hears it. Is my bubble popped now?
No. In that case, the bubble is still strong.
But why? A stranger still heard it. The spy heard it.
It comes down to your intent. What did you try to do? You tried to be private. You locked the door. You did everything a normal, reasonable person would do to keep something a secret. The law isn't going to punish you because you were tricked by a super secret spy.
That makes sense. I did my best to protect it.
You did. Now, compare that to a totally different story. What if we're sitting on a crowded city bus, and I stand up and shout to you from the back of the bus, hey, I stole that cookie.
Right, and everyone on the bus turns and stares.
In that case, you definitely lose. You were careless. You had no, what the law calls, reasonable expectation of privacy. You can't just announce your secrets in public and then turn around and ask the court to pretend no one heard you.
So the big lesson is, be careful where you talk. The walls and sometimes the closets really do have ears.
Precisely. But there's one kind of third party who is allowed to be inside the bubble with us.
Oh, who's that?
The helper.
The helper.
Let's do another scenario. Let's say I want to tell you my secret, but I only speak English, and you only speak French.
Mm-hmm.
We can't understand each other.
Okay, so we're stuck.
We need a translator. So we hire one. The translator comes into the room. Now there are three of us. Technically, a stranger is hearing the secret.
Yeah, that sounds like good who's back in the room.
You'd think so. But the law is practical. It understands that without the translator, we can't communicate at all. The translator is necessary. So the law says that if the third person is essential for the communication to happen, they count as part of the team. They are inside the bubble with us.
Oh, that's a relief. Otherwise, you could never talk to a lawyer if you didn't speak the same language.
Exactly. And it applies to other helpers, too. Think about a lawyer's secretary who has to type up a confidential letter, or an accountant who the lawyer brings in to help understand complicated financial documents. If they're part of the team that's needed to give or get the advice, their presence doesn't break the bubble.
Okay, so rule number 1, keep it private. Don't let random people hear it unless they are a necessary part of the conversation. Now, I want to talk about how you can lose this protection. The source material used a specific word for it, waiver.
Waiver. It sounds like you're waving goodbye. And really, that's exactly what it is. You're waving goodbye to your shield. You're voluntarily throwing it on the ground.
How does that happen? I mean, I assume you don't just walk into court and announce, I'd like to waive my privilege, please.
No, it's almost always done by accident or by being careless. And the most common way is what's called voluntary sharing.
Voluntary sharing. So this goes back to just gossiping.
It's exactly that.
Yep.
Let's say you have a very secret, very protected conversation with your lawyer. It's inside the bubble. It's safe. But then you go home that night, you're having dinner with your neighbor, and you say, hey, you are not going to believe what I told my lawyer today. I told him I stole that cookie.
Oh, I can see where this is going. My neighbor isn't my lawyer.
He is not.
Yeah.
And in that moment, you just waive the privilege. You told a third party. Now, the court can say, look, if you told your neighbor, why can't you tell us? You clearly don't think it's that secret anymore.
Okay, wait, hold on. I want to push back on that for a second. Why is that fair? I mean, I told my neighbor in private, in his living room. I trust my neighbor. Why does telling him destroy the totally separate secret conversation I had with my lawyer?
That's a really good question, and it gets to the heart of what a privilege is. Think of it this way. The shield, the privilege, is a very special gift from the law. The law's main job is to find the truth. It hates hiding the truth.
Right. It wants everything out in the open.
It does. So the law only gives you this special shield if you treat the secret like it's a precious diamond. You have to keep it locked away. The second you take that diamond out and start showing it to your neighbors, to your friends, the law says, you know what? You're not treating this like a diamond anymore. You're treating it like a common rock.
So I broke the circle of trust myself.
You broke it. And once you break it, you can't glue it back together. It's like spilling milk. You can't just scoop it back into the bottle. Once the secret is out, it's out.
Is there another way to waive it? What if? What if I just forget to use my shield?
Yep. That's the too late waiver.
Yeah.
Imagine you're on the witness stand in court.
Yeah.
The other lawyer asks you, do you tell your attorney that you stole the cookie? And you answer. You say, yes, I did.
Oh.
And then 2 minutes later, your lawyer, who was maybe daydreaming, jumps up and shouts, objection. That conversation is privileged.
But I already said yes. The bell has been rung.
It is too late. You have to raise the shield before the arrow hits you. If you answer the question, you've let the arrow through. You've waived the privilege for that question.
So you have to be on your pose. You have to be paying attention constantly.
You really do. You or your lawyer has to be ready to say, I object, or I assert the privilege immediately.
Okay, so we have the basics down. Keep it secret. Don't gossip. Use your shield in time. Now let's get into the specific relationships. This is the really juicy part, and I want to start with marriage.
The spousal privilege.
To me, this just sounds incredibly romantic. Like the law is tipping its hat to true love and saying, you know what? Your bond is more important than our courtroom. Is that what's happening?
It is. Sort of. It's partly true, but it's also, like everything in the law, very, very technical. And here's the first surprise. There isn't just one rule for marriage. There are two. Two completely different shields.
Two. Why two?
Because one rule is about protecting the person, your partner, and the other rule is about protecting the conversation, the secrets you tell each other.
Okay, this is already more complicated than I thought. Let's break this down. Let's invent a couple. Let's call them Bob and Alice.
Bob and Alice. Works for me.
So let's talk about the first rule. The name in the source was spousal immunity. That sounds like a superpower. Like, I have spousal immunity.
It is a kind of superpower. But it's a very specific one. It only works in criminal cases.
Only criminal.
Yes. Cases where the police are involved, where someone might actually go to jail. Not for, say, a car accident lawsuit.
Okay, so Bob is a bad guy. Let's say Bob robs a bank. He does it on a Monday.
Okay, Bob's a bank robber.
On Tuesday, he meets Alice. It's love at first sight. On Wednesday, they get married in a quick ceremony in Vegas.
That is a whirlwind romance.
It is. Now, on Thursday, the police show up and arrest Bob. They want Alice to come to court and testify against her new husband. Maybe she saw him counting the stolen money on Wednesday night.
Okay, so here's the question. Can the court force Alice to testify against Bob?
Well, the crime happened on Monday. He robbed the bank before they even met, let alone got married. Does that make a difference?
For spousal immunity, it makes no difference at all.
Really?
The rule is this. If you are married right now at the time of the trial, one spouse cannot be forced to give testimony against the other spouse in a criminal case.
Wow. So even though the crime happened when they were total strangers, the fact that they got married on Wednesday protects him on Thursday.
Yes. The purpose of this rule isn't about the crime. It's about protecting the marriage as it exists today. The law believes that forcing Alice to be the instrument of her husband's imprisonment would be so destructive to their marriage.
It would completely destroy it.
It would. So the law makes a choice. It decides that preserving the harmony of the marriage is more important to society than getting Alice's testimony.
That is a very powerful statement from the law.
It is, but, and this is a huge but, there is a catch, a really big one.
Okay, what's the catch?
Who holds the shield? Who gets to decide whether to use this superpower? Is it Bob, the defendant? Or is it Alice, the witness?
I would assume Bob holds it. He's the one trying to stay out of jail. He should be able to say, she's my wife, she can't talk.
That seems logical. But in federal court and in most states now, that's not how it works. The shield belongs to the witness. It belongs to Alice.
Alice holds the shield, so it's her choice.
Yes. This is called the witness rule. It means Alice can refuse to testify. She can stand up and say, that's my husband, I will not speak against him.
Sure.
And the court has to honor that. She can stay silent to protect him.
But what if she's mad at him? What if she finds out he's been cheating on her, or she just thinks bank robbers are terrible people?
Then we have a problem for Bob. If Alice wants to testify, she can.
And Bob can't stop her. He can't stand up and say, objection, spousal immunity.
He cannot. Under the witness rule, the choice is entirely hers. If she wants to take the stand and tell the jury everything she knows, she's free to do so. The privilege belongs to her, not to him.
Man, so Bob is just sitting there at the defense table, sweating, hoping that Alice still loves him after that whirlwind romance.
His entire fate could be in her hands. It makes for very high courtroom drama.
I'll bet. Now, what about divorce? Let's say Bob robs the bank, they get married, a year later it doesn't work out, and they get divorced. Then the trial happens.
If they are divorced at the time of the trial, the immunity is gone. Poof. Vanished.
Completely gone.
Completely. The whole point of the rule is to protect a current existing marriage.
Yeah.
If there's no marriage, there is nothing left for the law to protect. So the court can subpoena Alice, put her on the stand, and force her to testify.
Okay, so to sum up spousal immunity, it's for criminal cases only. It's the witness who chooses to use it, and you have to be married right now.
That is a perfect summary. You've got it.
Okay, so that's shield number one. Now let's talk about the second marriage rule. The source called it confidential marital communications. That's a mouthful. Let's call it the pillow talk rule.
I like that. The pillow talk rule. This one is very different. This is not about refusing to testify at all. It's about protecting the specific secrets that were shared between the spouses.
Let's go back to Bob and Alice. They are happily married. They're sitting at their dinner table. No one else is home. Bob leans across the table and whispers, Alice, I have to tell you something. I'm the one who robbed that bank.
Okay. That is a confidential marital communication.
Yeah.
It was made in private. It was made between spouses.
Right. Now let's fast forward 10 years. Bob and Alice get a nasty divorce. They can't stand each other. Alice wants nothing more than to see Bob suffer. So she goes to the police and says, I want to tell you what Bob told me 10 years ago at the dinner table.
Under this rule, she cannot be forced to, and in many places, she won't be allowed to.
Wait a minute. They're divorced now. You just told me that if they're divorced, the shield is gone.
That was for immunity, the shield that protects the person. This is for communications, the shield that protects the words. The law has a different goal here. The law says, We want people in a marriage to feel completely safe talking to each other. We want total honesty and trust.
Okay.
If you knew that anything you said could be used against you after a future divorce, would you ever truly be honest with your spouse?
No, of course not. You'd be afraid to say anything important.
Exactly. So to encourage that total trust during the marriage, the law makes a powerful promise. Whatever you say to each other in private while you're married will stay secret forever.
Forever. You mean even after a divorce?
Even after divorce, even if one of them dies. The words that Bob spoke at that dinner table are locked in a vault, and the law protects that vault indefinitely.
That is a much stronger protection. So who holds the key to this vault? Is it Alice's choice again?
No, this is another huge difference. For this privilege, usually both spouses hold a key. Or at the very least, the person who made the statement holds the key. So even if Alice wants to tell the secret, Bob's lawyer can stand up and say, "Objection, Your Honor, that calls for a confidential marital communication." And the judge will stop her from answering.
So for immunity, it's Alice's choice, but for communications, it's Bob's veto.
That's a brilliant way to put it, yes. Bob can veto her testimony about that specific secret conversation.
But just to be clear, it only covers things they said during the marriage, right? If Bob told her about the bank robbery the day before the wedding.
Then it is not protected by this rule. It has to be said while they're legally husband and wife.
Timing is everything.
In the law, it almost always is.
So are there any exceptions to this powerful pillow talk rule? When does the vault door spring open?
There is one very important and very sad exception. It's when the crime is against a member of the family.
You mean like domestic violence?
Exactly. Imagine Bob hits Alice, or imagine Bob hurts one of their children. Bob cannot then go into court, have Alice take the stand and say, "Hey, judge, you can't let her testify about what happened. We're married. It's a secret."
That would be horrifying.
It would be a complete perversion of the rule's purpose. The law says the privilege exists to promote marital harmony. But if you are beating your spouse or your child, the harmony is already shattered. You cannot use the shield that was designed to protect a happy family to hide the abuse that is destroying it.
That makes perfect sense. I am very, very glad that exception exists.
We all are. It's crucial.
All right. We've navigated the complexities of marriage. Now let's move to the big one. The one everybody knows from movies and TV. The lawyer. That classic line. I want to speak to my lawyer.
The attorney-client privilege. This is arguably the oldest and most sacred privilege we have. It's considered a cornerstone of the entire justice system.
So why is it so important? Why do lawyers get this almost magical protection?
Think about what a lawyer's job is. The legal system is a maze. It's complicated, it's confusing, it's frightening. You need an expert guide to get you through it. But that guide, the lawyer, cannot help you if they don't know the whole story.
Right. If I lie to my lawyer or hide things,
Yeah.
they can't build a proper defense for me.
Exactly. Your lawyer would be fighting blindfolded. So to make the system work, the law makes a fundamental deal with you. It says, tell your lawyer everything. Tell them the good, the bad, and the ugly. Be completely honest. And in return, we promise that no one else will ever hear it. It stays between you two.
So it's all about encouraging honesty so you can get the best possible help.
That's it. It's for the benefit of the client.
But like everything else we've discussed, there have to be rules. You can't just, say a secret to any person with a law degree and expect it to be safe forever.
Correct. There are very strict requirements. First, it has to be a communication between a client and a lawyer, or someone you were trying to hire as your lawyer. Second, and this is crucial, you must be asking for legal advice.
Let's run through some quick scenarios on that. My friend is a lawyer. We're out playing tennis on a Saturday. I say to him, "Hey, my backhand is awful. What am I doing wrong?"
Not privileged. That is tennis advice, not legal advice.
Okay. What if, after the game, I say, "Hey, can I borrow $5 for a sports drink?"
Still not privileged. That's just a loan between friends. It has nothing to do with his professional capacity as a lawyer.
Okay, last one. What if I pull him aside and whisper, "Hey, I just robbed a bank. The police are looking for a suspect. What should I do?"
That is privileged, 100%. You are asking for legal strategy and advice about a serious legal problem.
So the purpose of the conversation is what matters. It has to be about getting legal help. Now, I want to ask about something that seems to confuse a lot of people. The source material said that facts are not protected.
Yes, this is probably the most common misunderstanding of the whole privilege. People think that telling a fact to a lawyer somehow makes the fact itself disappear into a black hole.
Give me a story. Walk me through this.
Okay. Imagine you're standing on a street corner, just waiting for the light to change. You witness a car crash? A red car runs a red light and smashes into a blue car.
Okay, I saw it with my own 2 eyes. The red car is at fault.
Later, you go to your lawyer for some unrelated reason, and you mention to her, by the way, I saw a car crash today. A red car hit a blue one.
Now, that conversation with my lawyer, the words I spoke,
Yeah.
that's secret.
The conversation is absolutely secret. If a judge were to ask you, what did you tell your lawyer on Tuesday afternoon? You could raise the shield and say, I refuse to answer. That's privileged. Got it. But now imagine you're called as a witness in the lawsuit between the drivers of the red and blue cars. The other lawyer puts you on the stand and asks a very simple question. On that day, did you see a red car crash into a blue car?
Can I say I refuse to answer because I told that fact to my lawyer?
No, absolutely not.
Why not? It feels like they're trying to get at my secret.
Because the privilege protects the communication, not the underlying fact. You saw that crash with your own eyes before you ever spoke to a lawyer. That fact exists in your brain, independent of any conversation. You are a witness to an event in the world. You cannot hide a fact from the court just by laundering it through your lawyer.
Okay, I think I'm getting it. The words I spoke to the lawyer are locked in the vault, but the event I saw in the real world is not.
That is a perfect way to phrase it. Think of it like a map and the actual land. The conversation with your lawyer is a map of the territory. The privilege protects the map, but the territory itself, the car crash, is still there for everyone to see and ask you about.
The map is not the territory. I like that. Now, let's talk about what sounds like an action movie title. The crime fraud exception.
This is where things get very serious. This is the bright line that separates a lawyer acting as a defender from a lawyer acting as a co-conspirator.
Okay, let's use a timeline to make this clear. Let's compare yesterday versus tomorrow.
Perfect. Scenario A, the yesterday scenario.
Yeah.
You walk into my law office. You look terrified. You say, I did something terrible. I robbed a bank yesterday. The money is hidden under my mattress. The police are all over the news. Please help me.
Can you help me in that situation?
Yes, absolutely. The crime is in the past. It's completed. In our legal system, every single person, no matter what they've done, has a right to a legal defense. I can advise you. I can represent you in court, and everything you tell me is completely, totally secret.
Okay, that's the past. Now, scenario B, the tomorrow scenario. I walk into your office with a big smile. I say, I'm broke. I have a great idea. I want to rob a bank tomorrow. Can you look over my plans? Can you tell me which bank has the worst security system? And after I get the money, can you help me figure out how to launder it?
Stop. Right there. Everything grinds to a halt.
What happened?
The shield shatters. The privilege is gone. Totally and completely gone. That is the crime fraud exception.
But why? I'm asking you for legal advice about bank security and money laundering.
No, you're not. You are asking me to help you commit a future crime. You're trying to use me, a lawyer, as a tool to break the law. A lawyer is an officer of the court. Our job is to help people navigate the consequences of what they've already done. We cannot, under any circumstances, help you plan to break the law in the future.
So if I ask you for help with a future crime, our whole conversation isn't privileged. You might have to testify against me.
I might be legally required to. In fact, if I actually helped you, I could be charged as part of the conspiracy and go to jail myself. The law provides no protection for a client and a lawyer planning a crime together.
That is a very, very clear line. Past is safe. Future is dangerous.
The brightest line there is.
Now, what about big companies? The source notes mention a case called Upjohn, and it seemed a little complicated.
It can be, but we can simplify it. Just imagine a massive global corporation, like a giant car company.
Okay. Tens of thousands of employees.
So who is the client when the company's lawyer is investigating something? Is it just the CEO and the board of directors? Or is it also the engineer who designed the brakes, or the assembly line worker who installed them?
My first guess would be it's just the top bosses. They're the ones who run the company.
And for a long time, that's what many courts thought. But then came this landmark Supreme Court case, Upjohn v. United States. The basic story was that a drug company, Upjohn, suspected some of its employees were making illegal payments, basically bribes, to officials in other countries.
A big corporate scandal.
A huge one. So the company's lawyers flew all over the world and started interviewing everyone, not just the executives, but the mid-level managers on the ground, the people who were actually making the deals.
They were trying to get to the bottom of it internally.
Exactly. But later, the IRS, the government, wanted to see the lawyers' notes from those interviews. The government made the exact argument you just did. Hey, those low-level managers aren't the client. Only the top bosses are, so hand over the notes.
And what did the Supreme Court decide?
The Supreme Court said no. They took a more practical view. They said that in a huge company, the CEO in his corner office often has no idea what's really happening. Sometimes, to get legal advice, the lawyer has to talk to the truck driver to find out why the shipment was late. They have to talk to the engineer to find out why the part failed.
So the engineer's conversation with the lawyer is protected too.
Yes. The rule that came out of Upjohn is that in federal courts, the privilege can cover communications with lower-level employees as long as they are talking to the company lawyer at the direction of their bosses about matters within the scope of their job for the purpose of helping the company get legal advice.
That makes a lot of sense. It allows the lawyers to actually find out what happened so they can give good advice without everyone being afraid to talk.
That's the whole point.
Yeah.
It lets the lawyers do their job effectively.
Before we leave the topic of lawyers, I have one last question. It's about the oops moment that must happen all the time in the modern world. We all live on email. It is so easy to accidentally hit reply all or type the wrong name.
It is the recurring nightmare of every lawyer.
So let's say my lawyer writes up a super secret email, a memo about the weaknesses in my case. But he's tired, he has slippery fingers, and he accidentally sends it not just to me, but also to the prosecutor on the other side.
Oh, that's a stomach-dropping moment.
Is the secret dead? Did his one mistake just waive my privilege and ruin my case?
In the old days, 100 years ago, the answer was often yes. The law was incredibly harsh. It was a strict liability standard. You dropped it, you lost it.
That seems really unfair. An honest mistake can happen to anyone.
It was very unfair, and it became completely impractical in the digital age, where a single case can involve millions of documents and emails. It's impossible to be perfect. So thankfully, the rule changed. We now have what's called Federal Rule of Evidence 502.
And what does Rule 502 say? Does it forgive accidents?
It does. It says an accidental disclosure does not operate as a waiver if, and it's a big if, you can meet 3 conditions.
Okay, what are they?
1, the disclosure was truly inadvertent, a real accident. 2, you, the holder of the privilege, took reasonable steps to prevent disclosure in the first place. You had good systems. And 3, this is the most important part, you took reasonable steps to fix the error promptly after you discovered it.
So if my lawyer sends the email, realizes his mistake 10 seconds later, and immediately sends a follow-up email screaming, "Privileged document sent in error, please delete immediately,"
then the court will almost certainly say, okay, that was an honest mistake. The privilege is not waived. The prosecutor on the other side would be ethically obligated to delete it and pretend they never saw it.
That's a huge relief. It allows for human error.
It does. But on the other hand, if your lawyer is just totally sloppy, sends it to the wrong person, and doesn't even notice for 3 weeks, then you're probably out of luck.
So be careful, but don't panic if you make one little slip.
That's the new rule.
Okay, let's leave the law office behind. Let's go down the hall to the doctor's office. Let's talk about the physician-patient privilege.
This is one that feels very intuitive to most people. We all just assume that what we tell our doctor is private.
Is it? Is it strong as the lawyer's shield?
It's strong, but it has some important limits. The key one is that the information must be for the purpose of medical treatment.
Okay, scenario time. I go to the doctor. I've broken my arm.
Right.
I tell the doctor, "Doc, my arm is broken because I was climbing a ladder to clean my gutters and I slipped on some wet leaves."
That is privileged. The doctor needs to know how you broke it to treat it properly. Knowing it was a fall from a height helps him understand the forces involved and decide what kind of x-rays or treatment you need.
Okay, now let's change one fact. I go to the doctor and say, "Doc, my arm is broken because I was breaking into a warehouse to steal some copper wire and a stack of boxes fell on me."
Now it gets tricky. Does the doctor need to know you were stealing copper wire in order to set your broken arm?
Probably not. He just needs to know that a stack of heavy boxes fell on me. The crime part seems irrelevant to the medicine.
Exactly. So a court might later say that the part about your arm being crushed by boxes is privileged, but the part about why you were in the warehouse, the confession to the crime, is not. A court could potentially force the doctor to testify about that part.
Interesting. So the lesson is, only tell the doctor what's medically necessary to help you get better.
That's the safest course. But there's another, even bigger exception. This is what happens when you make your medical condition the main issue in a lawsuit.
What does that mean?
Let's go back to the car crash. You get hit by that red car, you sue the driver. You stand up in court and say, "That driver broke my arm, and it has caused me terrible pain. You owe me $1 million.
Okay, pay me my $1 million.
The other driver's lawyer stands up and says, hold on, prove it. I want to see all your medical records for your arm. Maybe you had a pre-existing injury. Maybe you hurt it playing tennis last year.
Can I say, no way those are private medical records?
You cannot.
Why not? They're still my private health information.
Because you started the fight. You put your arm on the table, so to speak. You made the condition of your arm the central issue of the entire lawsuit. You can't use the privilege as both a sword to attack someone, pay me for my injury, and as a shield to hide the evidence about that very same injury.
That seems fair. If I'm asking for money because of my arm, they have a right to see the records about my arm.
That's the logic. You have waived the privilege by filing the lawsuit.
Now, what about mental health? Therapists, psychologists, psychiatrists, is that treated the same as a regular doctor for a broken arm?
Actually, no. It's treated as being much, much stronger. The Supreme Court decided a very famous case on this called Jaffe v. Redmond, and they said that the psychotherapist patient privilege is critically important.
Why is it more important than a broken arm? Ailments are ailments.
Think about the nature of the treatment. If you have a broken arm, the doctor can look at an x-ray. He can see the break. He can fix your arm, even if you don't say a single word.
True. The bone is right there on the film.
But mental health is different. The medicine is the talking. The cure comes from being able to talk about your deepest shames, your most embarrassing moments, your darkest fears. If you thought for even 1 second that those intensely personal words could be read aloud in a public courtroom, would you ever be truly honest?
No way! I would clam up immediately.
And if you stay silent, you don't get better. The therapy doesn't work. The Supreme Court recognized this and said that society has a profound interest in people getting effective mental health treatment. And for that to happen, we have to guarantee almost total privacy.
So I can tell my therapist things that might not even be safe to tell my regular doctor.
In many ways, yes. The protection is incredibly high. Unless you are making a specific, credible threat to hurt yourself or someone else imminently, the therapist's office is usually one of the most secure vaults there is.
Does this also cover people like social workers?
Yes, it does. The Supreme Court was very clear about that. They said the privilege extends to psychiatrists, psychologists, and licensed clinical social workers, recognizing that many people get essential mental health care from social workers.
That's really good to know. It protects more people.
It does. Now, there's one more big shield we have to talk about. This one isn't just a rule of evidence. It's in the Constitution itself. The Fifth Amendment.
I plead the Fifth. The most famous line in any cop show.
It is. It comes directly from the Bill of Rights. And the core idea is that no person shall be compelled in any criminal case to be a witness against himself.
The simple translation being, you have the right to remain silent.
Exactly. The government cannot force you to point the finger at yourself and admit you committed a crime. It's a fundamental right designed to protect the individual from the power of the state.
You said individual, and the amendment says person. Does that word choice matter? I mean, are we only talking about human beings?
That is a very sharp observation.
Yes.
You're only talking about human beings.
What about a corporation? A huge company like Amazon or Ford? Can a corporation plead the Fifth?
No, it cannot.
Why not? A corporation is a legal person in many ways.
It is, but the Supreme Court has said for over 100 years that this particular privilege is purely personal. It's about protecting the dignity and conscience of a human being. A corporation has no conscience. It has no soul to protect. It's a creation of the state, a legal fiction.
So if a judge issues a subpoena ordering a company to hand over its internal documents, even if those documents will prove the company committed a massive crime, they have to turn them over.
They have to. They cannot assert a Fifth Amendment privilege and remain silent. An individual officer of the company could plead the Fifth if their personal testimony would incriminate them, but the company itself must produce the papers.
That's a massive difference.
It's a huge one, and it leads to another twist with the Fifth Amendment, and that's the idea of an immunity deal.
The deal. This is another movie classic.
It is. So imagine the police arrest you. They know you stole a car. They have you dead to rights. But they don't really care about the car theft. They want the big fish. They want the murderer you work for. They know you have information.
Okay. But I don't want to be a snitch. I don't want to say anything. I'm going to plead the Fifth.
So the prosecutor comes to you and says, okay, we'll make you a deal. We will give you use immunity. That means if you tell us everything you know about the murderer, we give you our solemn promise that nothing you say can be used to prosecute you for the car theft.
That sounds like a pretty good deal for me. I get off scot-free for the car.
It is a good deal. But here's the trick. Once they give you that legally binding grant of immunity, Can you still plead the Fifth and stay silent?
I don't know. I guess not.
You cannot.
Why? I thought it was my constitutional right.
Think about the logic. The Fifth Amendment protects you from self-incrimination, from getting yourself into criminal trouble. But if the government gives you a legally binding promise that they will not get you in trouble based on your words, what's left to be afraid of?
The danger is gone.
The danger is gone. And if the danger of self-incrimination is gone, then the right to remain silent based on that danger is gone too. The judge can now look at you and say, you have immunity. You are safe. Now, answer the question.
And if I still refuse to talk?
Then you can be held in contempt of court and sent to jail. Not for the original car theft, but for the separate crime of refusing to obey a lawful court order.
So immunity is like a key. The government uses it to unlock your mouth.
That is a perfect way to describe it. They trade your legal safety for your testimony.
We have covered so much ground. We just have a little bit of time left for what the source called the other secrets. Maybe a quick fire round.
Let's do it.
Okay, first up. Priests, ministers, rabbis.
Clergy.
The clergy penitent privilege. This is one of the oldest ones, deeply respected by the courts. If you as a penitent are making a confession to a clergy member in their role as a spiritual advisor, that communication is almost always privileged.
And who holds that shield? Me or the priest?
You do, the penitent. The priest cannot waive it without your permission. Okay. What about accountants?
This one is tricky. There is no general accountant-client privilege under federal law. So in a federal tax fraud case, your accountant might have to testify against you. However, many individual states have passed laws creating a privilege for accountants. So it really depends on where you are and what court you're in.
So not as solid as the lawyer privilege.
Definitely not. Finally, what about journalists, reporters who want to protect their confidential sources?
Right. This is always in the news. A reporter says, I promised my source I wouldn't reveal their name, and I'm going to jail to protect them.
And they often do.
So there's no legal protection.
At the federal level, the Supreme Court has said there is no journalist shield in the First Amendment.
Yeah.
So a federal prosecutor can force a reporter to reveal a source. Again, some states have passed shield laws to protect journalists, but it's a very risky and patchwork area of the law.
That's a dangerous position for a journalist to be in.
It really is.
Wow. Okay, let's just take a breath. We have built a massive and complicated map of secrets today.
We really have. We've explored that whole circle of trust.
So let's try to quickly summarize the big takeaways. Number one, confidentiality is king. You have to keep your secret in a bubble or the law won't help you. Don't let Dave in the room.
Right. Number two, marriage is complicated. You have two shields: immunity, where the witness gets to choose in a criminal case, and communications, the pillow talk rule that protects the words forever.
Number three, lawyers. Remember the red car. The privilege protects the conversation, not the underlying facts you know. And whatever you do, don't ask your lawyer to help you plan a future crime.
Absolutely. Number four, doctors and therapists. Your physical health secrets are protected when they're for treatment, but your mental health secrets are in an even stronger vault.
And finally, number five, the Fifth Amendment. It's a personal right for humans to stay silent. Corporations can't use it, and the government can use an immunity deal as a key to make you talk.
That's a fantastic summary. You could teach a class on this.
So, after all that, I want to come back to the big why question. Why does society do all this? The whole point of a trial is to find the truth. Why do we have all these complicated rules designed to hide the truth?
That is the ultimate tension, isn't it? And
Right.
You're right. The primary goal is truth. But the law recognizes that a society is more than just a truth-finding machine. We have other values. Is finding the truth in one specific case more important than the entire institution of marriage? Is it more important than ensuring people feel safe enough to seek mental health treatment?
So it's a balancing act.
It's a massive balancing act.
Yeah.
The law has decided that certain relationships between spouses, with a lawyer, with a doctor or therapist, are so fundamental to a functioning humane society that we are willing to pay a price. And that price is that sometimes a piece of evidence will be kept out of court in order to preserve that vital trust.
So the privilege is the cost of having trust in our world.
That's a beautiful way to put it, yes.
Before we go, I have one last final thought, a provocative one that came from our source material. It was a little note that said, a wrongful disclosure is not a waiver.
Right. What that means is if someone steals your secret, if a burglar breaks into your lawyer's office and takes the file,
Yeah.
you haven't waived the privilege. You didn't do it voluntarily.
Okay, but think about the world we actually live in now. A world of hackers, cloud servers, data breaches, WikiLeaks. Imagine I send a totally privileged secret email to my lawyer, but a hacker in a basement halfway around the world breaks into the server and steals it. And then they post it on the internet.
A complete nightmare scenario.
Millions of people read it, the news reports on it, it's everywhere.
The secret is out.
Now, legally, according to that rule, the privilege still exists, right? I didn't waive it, the hacker did it.
Technically, that is correct. Your lawyer could stand up in court and make a motion saying, Your Honor, this email is privileged. The jury cannot see it, and it cannot be admitted into evidence. And the judge would probably agree.
But so what? The jury reads the internet. The judge has seen it. The public knows the secret. The bell has been shattered, not just unrung.
You're right. You can't make people unknow something.
So here's my question to leave everyone with. In an age of digital leaks, does legal privilege even matter anymore? What good is a legal shield if technology has made the walls of the castle turn to glass?
That is perhaps the single biggest legal question of the 21st century. The law is a set of rules for a physical room called a courtroom. But it has very little control over the global room we call the internet. We may be entering an era where we have legal privacy on paper, but almost zero actual privacy in reality.
That is a very sobering thought to end on.
It is. It's something we should all think about every single time we hit the send button.
Well, on that note, thank you for guiding us through this incredibly complex maze.
It was my absolute pleasure.
And thanks to all of you for listening. Keep your shields up and be careful who's hiding in the closet. We'll see you on the next deep dive.